Major breaking news out of the United States Court of Appeals for the Sixth Circuit in the state of Michigan. A 2-1 loss for the Second Amendment as to whether or not a commercial gun range, a shooting range that includes a 1,000-yard shot, specifically a lane for a 1,000-yard shot, among other things, whether or not essentially a restriction or ban on the creation of such a range on private property, whether or not that violates the Second Amendment. 2-1 decision says it does not violate the Second Amendment, but the logic and the analysis of the 2-1 decision of the two judges in the majority, not quite up to snuff. I don't think this is a case of anti-gunners just knee-jerk reacting against guns, but I do think it was wrongly decided. We're going to break it down when we get back in one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new book, Israel Disarmed, What the October 7th Attacks Teach Americans About the Right to Bear Arms. Very important that you read this book on Israel, how they disarm their citizens, how they refuse to adopt a Second Amendment despite the fact they are at risk of attack of what we saw on October 7th, and the lessons that they learned and the steps they're now taking to fix this mistake. We always want to learn from the mistakes of others. It is always better and less costly to learn from the mistakes that other people make, and we don't want to make the same mistakes here of having massive gun control and disarmament and making it hard for private citizens to be able to defend themselves. Let us learn from the mistakes of the Israelis and the Israeli government. Israel Disarmed, Mark Smith's new Second Amendment book. All right, folks, so we have not great news out of Michigan. The United States Court of Appeals for the Sixth Circuit in a 2-1 decision has found that a lawsuit brought on behalf of the Second Amendment by a group of plaintiffs that wanted to create a gun range in an agricultural area on private property were not allowed to do so. They sued under the Second Amendment, claiming that this violated the Second Amendment right to keep and bear arms because it restricted the ability of people to train. Now, the name of this case is Oakland Tactical versus Howell Township there in Michigan. I'll put a link to this decision down below. And the 2-1 decision against the Second Amendment was not really analytically crisp or correct. I don't think this decision against the Second Amendment was a result of just anti-gunners, knee-jerk reaction, looking for an excuse to rule against guns. I don't think that's what happened in this case. I think it was just logical reasoning that wasn't quite right by the two judges in the majority. I should mention that the judge in the minority, and this is important historical fact, the judge in the minority here is Raymond Kethledge, who was on the short list to be on the U.S. Supreme Court. It came down to Judge Kethledge or Judge Brett Kavanaugh. I also think it was Judge Thomas Hardiman was also in the running out of the Third Circuit, and Raymond Kethledge did not get that slot on the U.S. Supreme Court. Justice Brett Kavanaugh, of course, got that slot, and that's where we are with that. Nevertheless, Judge Raymond Kethledge wrote the dissent here and said that he thought that at a facial level, or at least at the first step level here, it appeared as if this rule that restricted the ability to open this commercial gun range, shooting range, violated the Second Amendment, and the case should continue, but the majority disagreed. Specifically, the majority's language seems very odd, and the good news is they sort of got it right, but then they didn't take it to its logical conclusion, which is odd. What they really started off by saying, of course, is that the plain text of the Second Amendment, if it's implicated by modern-day gun control law and the anticipated or desired conduct of the plaintiff, in this case, Oakland Tactical and the other plaintiffs, which wanted to create a gun range and use the gun range, if the text is implicated, you know what happens. The burden shifts to the government to come forth with historical analog laws to justify the restriction on the right to keep and bear arms. Now, what the judges here said is that the right to train is not in the plain text of the Constitution. It's an ancillary right. Now, this is really not correct. They got part of this correct. They said that, yeah, there are ancillary rights under the Second Amendment. They do talk about that the right to train is an ancillary right, so it is a protected constitutional right, because you can't have the right to keep and bear arms and to engage in self-defense activities if you don't first and foremost train. So at one level, they got that conceptually right. But then they go on to basically say that although the right to train is conceptually protected, there's no basis to conclude as a textual matter that the right to train with firearms on a 1,000-yard range is somehow protected. But this is not correct, because the text of the Second Amendment, as I've written about before in Ammoland, for example, the right of the people to keep and bear arms includes the right of ancillary rights, the right to be able to acquire guns, obviously, the right to be able to practice with your guns, the right to be able to train with your guns, the right to be able to have ammunition, the right to have a trigger, a right to have a barrel. These basic things are not in the text of the Second Amendment itself, but they are in the text because they're ancillary rights that are necessarily part of the text of the Second Amendment. That's how it's always understood. So in light of the fact that the right to train is an ancillary right part of the text of the Second Amendment, and the fact that this law by Howe Township, Michigan, infringed upon or hindered the right to train, that by necessity infringed upon the right to keep and bear arms, because it infringed upon the ancillary right to keep and bear arms, because it infringed upon the right to train. So at that level, what should have happened in this case is the burden of proof should have shifted to the government, to the Howe Township of Michigan defendant, to say, okay, come forth with historical analog laws that would justify restricting the ability of people in their own property to be able to set up a gun range, even with a 1,000-yard range. It doesn't matter. Show us the historical analog laws. And if you can't do it, then really, you can't do it under the Second Amendment. But basically, what the judges did here is, rather than taking it at that most basic level, that the text of the Second Amendment is implicated, the burden shifts to the government to come forth with historical analog laws to justify. Instead, they tried to play this game and said, well, then what they engaged in was a tiers of scrutiny balancing act, interest balancing. And what they really were saying is this. They were saying, look, the plaintiffs have not established why anyone needs to have a 1,000-yard gun range or shooting range in order to exercise your Second Amendment rights. So specifically, here's what the majority wrote. Let me read it to you, and you tell me if you agree with it. Although plaintiffs are correct that the Second Amendment protects the right to engage in commercial firearms training as necessary to protect the right to effectively bear arms in case of confrontation, they make no convincing argument that the right extends to training in a particular location or at an extremely long distances Oakland Tactical seeks to provide. Then it goes on to say, it is difficult to imagine a situation where accurately firing from 1,000 yards would be necessary to defend oneself, nor have plaintiffs identified one. To the extent that historical evidence is probative of the scope of the right derived by necessary implication, like the right to train, the historical evidence plaintiffs present, a handful of examples of riflemen seeking or making shots from 600 to 900 yards during the Revolutionary War, is not convincing. Assuming these examples show that the founding era public understood military proficiency to include accuracy at these long ranges, they do not establish that the Second Amendment right, goes on to say, was similarly understood. Okay, no, wrong, analytically sloppy poppy, sorry, really not that hard. The right to keep and bear arms is the text. It has ancillary rights. One of those ancillary rights is the ability to acquire the gun, to acquire the bullets, to acquire a trigger, to acquire a barrel, to train. They admit this. Once you have the right to train as part of an ancillary right implicit in or necessarily part of the text of the Second Amendment's right to keep and bear arms, the text is now implicated by a law which the Howe Township is allegedly passed that restricts the right to train. Okay, period, full stop. Period, full stop. That is a restriction. That is an infringement because, as you know, using the dictionaries used by the Supreme Court from the founding era, the definition of shall not be infringed, i.e. the definition of infringed or infringement or to infringe, is to hinder or to destroy. To restrict the ability to fire any level, remember the argument here by the plaintiffs was even though the range may be 1,000 yards long, the training will be for less than 1,000 yards long. There'll be a 25-yard range, a 10-yard range, a 50-yard range, a 100-yard range. It may go out to 1,000 yards, but there's all sorts of training within the 1,000-yard limit as well. And this is a restriction, according to the plaintiffs, that restricted their ability to create on their own property this firearms range in a rural agricultural area of the town. But the town did not let them, allegedly in violation of the Second Amendment. But the problem with this, what I just read to you from this opinion, is that they're immediately trying to engage in a distinction. So rather than saying that the right to train has been hindered here, and therefore the burden shifts to the government, the judges are now trying to make excuses and make arguments against the plaintiffs. Now, here's the thing. The reason why there's a discussion, this is my guess, the reason why the plaintiffs in this case talked about American Revolutionary firearms being used at 600 yards or 900 yards, it doesn't matter if you need to make that shot today. What that proves is that at the time of our founding, people were firing ammunition. They were using guns to fire at targets 600 to 900 yards away, which means that any suggestion by the town in this case that there's a historical analog set of laws that restrict the ability to have a 1,000-yard shooting range, right, cannot possibly be the case because, number one, I don't believe the government, from what I can tell from this opinion, I don't believe the government here identified any relevant laws restricting gun ranges or anything or gun training of the sort we see here, number one. And number two is the reason why that historical example of people firing 600 to 900 yards at the time of the founding is relevant is because it really shows that why would you have restrictions at the time of the founding on the length of a gun range where you can practice when people are making those long shots at the time of the founding? So really, it's not necessary to prove that people were making 600 to 900 yard shots at the time of the founding. It kind of reaffirms the importance of the silence of the fact there's no laws that the government could point to that shows these restrictions were appropriate. So what this court did in the 2-1 decision, the two judges of the majority, basically said, hey, we're going to defeat the Second Amendment right at the textual level by saying that there's no textual basis to have a gun range and be proficient at firing at 1,000 yards. But it doesn't matter. That's like saying, well, you have no right of free speech under the First Amendment to read a book that's longer than 1,000 pages. Why do you need to have a book more than 1,000 pages? You have 999 pages to read. That's enough. Or likewise, let's say you're a college professor that has 1,000,000 books and you want to buy 1,000,001 books for your library, and the government says, you don't need that extra book. You got 1,000,000 books. You got so many books that if you're not going to be able to read them all between now and the time you die anyway. So therefore, there's no reason to have that other book. No, you would never be able to get away with a restriction on no books more than 1,000 pages, or you can't have more than 1,000 books in your library. That's it. You're done. No one would conceivably think that that's constitutional, involving the First Amendment's right to free speech, for example. And certainly that sort of logic also applies to the right to keep and bear arms. And again, the text clearly, the right of the people to keep and bear arms includes the right to train. They essentially concede the point. And because of that, this restricts that. They should be obligated, meaning the government should be obligated to come forward with a long-standing list of government regulatory laws going back to the founding that would justify this kind of regulation. Obviously, they're not able to do so, is my best guess. Nevertheless, here you have the government and the judges saying, oh, it doesn't matter. You still can't do what you say, and we don't think it violates the Second Amendment, so the burden never shifts to the government. I think that's just analytically wrong. So we'll see what happens. I think this is the kind of case that probably will not go to the U.S. Supreme Court. I think there are other cases in the pipeline, is my guess. I'm not sure the Supreme Court would be interested in a case involving the right to train in commercial firearms ranges today. That's not to say the Supreme Court would not reconsider this in a couple years, depending on what happens with other cases in the pipeline. But for the moment, we'll see what happens, what these lawyers do, whether they seek en banc review from the Sixth Circuit, or maybe they'll seek cert from the Supreme Court. Supreme Court? I just don't know. Only time will tell, and we'll keep you apprised of this case as it develops. But in the meantime, I appreciate you tuning in to the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. Don't forget to subscribe and resubscribe. We're trying to get to 150,000 subscribers. And don't forget to check out on Amazon my new book, Israel Disarmed, what the Americans can learn about the right to keep and bear arms from what happened in Israel and how their lack of a Second Amendment cost them dearly on October 7th, 2023. And we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.